the decriminalization of cannabis and other drugs for that matter. Very excited about the discussion. So, John, thank you so much for taking the time away from your cottage to join us today.
You're very welcome, though I can't confess to having actually taken time away from the cottage. I'm speaking. It's going to be an interesting time. I don't think that, realistically speaking, October the 17th is going to be the end of the world. I doubt very much that everyone's going to hit the streets high as a kite by 6 p.m. on the 17th. It won't come as a shock to most people that a large number of Canadians already smoke marijuana or use marijuana in medical form. Mm-hmm. Some of the numbers are extraordinarily high, no pun intended. Additionally, there's a situation where, we are in this country, unfortunately, the highest level of usage among teenagers of any country in the world. So the war on drugs, such as it was, has been and quite properly spoken to by our federal government at the moment, a total failure when it comes to preventing children from using drugs. And the legalization and regulation, more importantly, of drugs isn't to say, please go drink or please go take drugs. It's not an encouragement to use these drugs. It's a new approach for the control, regulation, and actual legalization of these drugs so that we're not using the criminal justice system as a way to deter people. The greatest comparison that I can make is with respect to tobacco. Self-harming activities are not to be encouraged. People drinking too much or smoking too much or hurting themselves, not wearing helmets while riding bicycles is not to be encouraged. But at the same time, if you want people to stop doing things that aren't harming others and are only harming themselves, you've got to talk them into it. You're not going to arrest people into not smoking cigarettes. What we did was turned it into, quite properly, a public health issue. And we said to people, you stink. Your clothes stink. You're not sexy. You're not cool. It's awful. We took it out of advertising. We took the cool advertising away. And we told people that it was not only dumb, but it was bad for you and that you would be stupid to do it. And we now have a culture, I believe, certainly amongst young people, where if you're smoking, you're dumb. And people aren't doing it nearly as much. We cut the smoking level down in half, and we didn't arrest anyone to do it. So this is a new approach. Hopefully it'll be a more successful approach, and hopefully it's a more sensible approach because the old one was clearly not working.
Well, this is why I was very excited to have you on the show, John, because I didn't think you'd be shy about sharing your views and your opinions. So I think it's going to be
not running for anything, Stuart. There are some people that want to be, if you will, are looking for another job. I'm not. I've been a defense lawyer for 34 years, and this is where I belong, and this is where I intend to be. So I'm going to tell you the truth, whether it sounds good or not.
No, and this is what's going to make this. This is why we budgeted an hour, because it should be a great discussion. And you made already some great points, including the point that I often make to our corporate clients, which is that the world is not going to end. The sky is not falling. And the reality is, and I want to get a bit more into what you think will change in October and the months following. But as I've said, you've already got medicinal use of cannabis, which is accepted and becoming far more widespread. You've unofficially got recreational usage, which is at extremely high levels throughout the population. And it's now going to become decriminalized as of October. But the world isn't going to change overnight. And from an employer perspective, the sky is not falling. And I always harken back to alcohol. Alcohol is legal. And yet we don't have people who are coming to work plastered or drinking at work, aside from the context where it's acceptable and in some cases encouraged. So it is easily managed as opposed to what some employers seem to think.
Well, we've had the old age-old reefer madness meme, I guess, about, people on the streets falling into the gutters immediately. In fact, in the legalizing jurisdictions, Colorado, Washington State, usage has not increased dramatically at all. The people who did smoke marijuana are not, illegal anymore. But for the most part, people aren't running out to try something that they haven't tried before. And it's not a question of, we're causing large segments of the population to go nuts. That just doesn't happen. Physically, empirically, and historically, it just hasn't happened. And there's also, speaking of the war on drugs, so many collateral consequences to the war on drugs that have been so negative for our society in terms of the police, in terms of people's lives being ruined by minor drug charges, the ability to travel and be employed. And I will say it directly, the drug war has been racist. You are much more likely to be arrested, charged, and prosecuted if you are a young black kid in North York than if you are a young white kid in Rosedale. It's just the way it is. And as a result, you have people being disqualified already at a disadvantage educationally, locationally, economically, who adding a conviction for marijuana to their resume is just deadly to their futures. And it's suppressing a large segment of the population. And the collateral damage is just absolutely punitive. So we're moving in the right direction, as we discussed a moment ago. In fact, the arguments for the legalization of marijuana are exactly the same arguments that can be made for the legalization of all drugs. Mm-hmm. The problem with criminalization is that you drive people underground, and it's about the money. You have people who are making a fortune selling drugs to our white communities. Our housing projects are unfortunately drugstores that, of course, are selling to the community at large. And we're looking at a whole series of problems in our community now. And if you start from the migrant issue, people are coming to the United States and fleeing the United States for Canada because their situation in Central America is disastrous because of the drug war. The cartels and the gangs there are shooting each other at an alarming rate. The murder rate is incredible. The journalists, the politicians, the police are either corrupted or in danger. And people are fleeing this drug war in Central America to the States and then to Canada. They come to Canada. We then have a complaint in our city, particularly now, about what amounts to a drug turf war. We have neighborhoods who are at war with other neighborhoods, and it's over money. It's over the drug war. You talk about the guns in the city of Toronto, which are, of course, an enormous problem. People should be caught, prosecuted, and incarcerated for using guns. But the reason they're doing it is because of money, and it's because of drugs. You don't have people shooting each other over beer anymore. Excuse me. Al Capone wasn't shooting, his rivals over beer. It was over money. If you take the money away, you're in a position where you're in much better shape to try and give people alternatives that they're going to take.
Yeah, and you made a great point earlier about the selective arrests and prosecution, and the person in certain areas of the city, as opposed to in Rosedale, being arrested and convicted. And of course, our human rights code protects people from being discriminated against on the basis of a record of offenses. But you can discriminate against someone who has a conviction and has not been pardoned. So, and this is one of the questions I had for you. Actually, a couple of questions on that line. First of all, so we know that decriminalization takes place in October, but are people still being arrested now, or have the cops sort of backed off while they wait?
Well, it depends where you are. Unfortunately, there's also very locational problems. If you're in this part of the world in Northern Ontario and you're arrested for drugs, you are going to be prosecuted. The chances are that you're going to get a criminal record for it, not even a diversion or a discharge. Recently, I was in Parry Sound Court, and people were being given serious fines for simple marijuana possession. Recently, since the since we have determined that we're going to legalize, I guess probably when did Trudeau announce it 2 years ago? We've arrested 50,000 people a year for simple possession offenses. 50,000 Canadians a year have been arrested. Maybe it's their last shot at the subculture, I don't know, but it hasn't stopped. In the city of Toronto, the prosecutors take a pretty liberal view and very often will divert these charges so that you'll do some community service work or something of that nature to have the charges dismissed. But the arrest itself is still being disclosed on any, as we are about to discuss, I'm sure, level 4 records check, where if you're applying for a permit clearance so that you can take your kid on a hockey trip, or you're, for that matter, trying to go to the United States, the mere fact that you've been arrested for this will be disclosed.
Right. And again, if you've been convicted, you can be shut out of a job, and there is no breach of your human rights in that context unless you've been pardoned. So that's one thing I was hoping you'd explain, because I get this question a lot. And we have people who have convictions. Sometimes they're 6 months old, sometimes they're 25 or 30 years old. But they're now finding it's preventing them either from going on the hockey tournament to the States or getting a job. So how does someone go about getting a pardon?
Well, unfortunately, there's no pardons anymore. They're called record suspensions, effectively. The Harper government changed the rules and made it much more difficult to get what we used to call a pardon. The time that you had to wait to apply for it increased, the financial cost increased, and the difficulty of obtaining this increased, there's a huge backlog of applications as well. So it's not as easy as it may sound. And the next problem is that in some jurisdictions, Washington State particularly, when legalization was approaching, the government had a very serious plan for purging these records, for giving people blanket pardons, for getting these things out of the computer when you're trying to travel or otherwise have matters disclosed. We have no such system in place here at all. There's been no movement whatsoever by the current federal government to deal with what they're going to do with these records once October 17th comes along. So you're now in a situation where you're in a very difficult position. If you've been convicted in the past, it may take years to purge this record, and then you're into the next problem. The Ontario government passed a law which is coming into force on November the 1st, and we hope it still will, and that Mr. Ford won't change his mind on this, that is going to prevent some of these disclosures by local police forces. But effectively, it's the Wild West out there now and has been for some time. You're down to the individual police force. If it was Peterborough or Guelph or Sudbury police force that charged you, you're in a situation where they might disclose it on their own, regardless of what, you know, the general the consensus might be about what would be fair-minded in the circumstances. So the application for the pardon takes time. I'd be well advised to get advice about it, but it's been made more difficult by the Harper regime, and the current government has made no effort to make it easier, nor have they got any position in place for how they're going to go about blanket remedying all of these convictions that have taken place, even in the past 2 years.
Well, I mean, that's interesting. I find it interesting that our human rights code, at least in Ontario, still refers to pardon, which even though that's not the current term, but it's going to be a real issue. And as the point you made, I mean, as far as criminal records checks, background checks, I mean, we have clients, a lot of them are US based, and they, you know, as a matter of course, they will ask for the vast criminal background or background searches. And by the way, Rob, I see we have a question. We will get to that in a second. But thank you. Hopefully, we're gonna have a lot of them today. But I find some employers just ask for background checks with no good reason whatsoever. Now, there are contexts or industries or positions where you should have the right to get a background check. In many cases, there's no reason to. And the problem, as you said, is sometimes you have police forces or individuals who just act on their own. I used to have investigators who could go and get banking information. They could tell me not only where someone banked, but get the account number, the balance, their regular transactions, all that. And that has been largely eliminated. But nevertheless, if you know the right people, you can still get a lot of this information, including not only convictions, but as you said, arrests or even interactions with the police, which, to your point earlier, impact certain groups more than others.
Well, you're younger than I, Stuart, but at the same time, I'm glad that I had my young, shall we say, adventures at a time before the internet, because at this point, your history, your personal background and circumstances, realistically, can be out there online. It can be out there in a police blotter. It can be out there in many ways that, you know, is going to affect you for a very long time. I'm not sure it's increased the level of social, propriety, but nevertheless, you're in a situation where many of these things are going to haunt you for life. You know, you're a police force now in the current Wild West until we get this new law in effect. If they're asked by, you know, your prospective employer for a deep level 4 records check, and perhaps your employer's wised up and said that's what you're going to need for this job that has nothing to do with children or the public and at large, but they've asked for everything, the police can literally provide to them that you made a complaint about your neighbor's stereo because that's on file. Because one day, you know, you got, 4 parking tickets on the same block. They can provide this information to your prospective employer. Anything that's on their file, anything that ever comes up can be disclosed. And so realistically speaking, your life can be an open book, and our privacy laws really need to be enforced and tightened up because we've lost the plot to some extent on this.
Yeah, well, I think that's a great point. Where I thought you were going to go is more on the social media front. And I always say I'm just glad I grew up before the age of cell phone cameras and Facebook, because I can only imagine what people would find about me and all of my friends. And this is why when I have employers who are doing their background checks, and by the way, to digress for a second, I still have employers who are scared to do social media searches for applicants. And I always say if it's public information, it's fair game. But among other things, take it with a grain of salt. And just because you see an applicant with a beer in their hand in one picture doesn't mean you should exclude them. If you see every single picture with a beer, maybe a different story, or maybe bring it back to this show of a joint in their hand. Again, a one-off, maybe you're not so concerned. If it's every single picture, a different story. But to bring it back to what you were saying, I mean, first of all, privacy rights have got to be increased, and these background checks that some employers do as a matter of course have got to be controlled. But then what I also wanted to ask you about, because this is something that comes up all the time, and then Rob, I know we still have a question that I've forgotten to get to, but this comes up all the time in our firm. We have an employer call us and they say one of our employees was arrested yesterday or this morning or last week for whatever it is. In this context, let's say for possession of marijuana or cannabis. So they've been charged, but we don't want them around. So can we fire them? And so I often get referrals from criminal lawyers, and I often refer clients to criminal lawyers because we have individuals come in who have been charged with possession and then fired. And are you seeing the same thing where people are now fighting on two fronts?
Well, two words for you: Roberto Osuna. You know, he was charged with an offense which he may or may not be guilty of, and there was immediate consequences from his employer. He was suspended for a lengthy period of time. Whether they did their own investigation or not, or what level of investigation they did, remains to be seen. Whether he participated in the investigation remains to be seen. But, you know, the presumption of innocence has long since become less favorable. I mean, you know, I don't mean to take another road that we may not go down, but the Me Too movement is very similar as well. I mean, the
point I was going to make, exactly.
In the employment situation, you know, an allegation of sexual harassment in the workplace can have disastrous consequences, whether it's made out or not. And when we used to consider these type of allegations, serious misconduct, serious criminality, serious sexual misconduct, the reason we have a criminal justice system is because those consequences to those sorts of allegations are so draconian, so severe, and so life-altering that we wanted to have due process. We wanted to have a format under which an independent arbiter of fact would listen to both sides of the evidence and come to a conclusion, preferably on a high standard of beyond a reasonable doubt, because the consequences are life-altering. If you're convicted of a sexual assault offense, you're in a position where you're on a SWARA, a sexual offense registry all over the country. You are unlikely to travel for the rest of your life. You'll never go on a school trip for the rest of your life. You'll never be employed for the rest of your life. And this can be literally a butt grab, and it will be called sexual assault, appropriately so. But the consequences of it are absolutely devastating. So having due process is critical. When some employer hears my employee was charged with DUI or he was charged with, you know, a drug offense, and immediately goes to, you must be guilty, you're going to lose your job, the level of, you know, due process and fair play that is lost when that happens is really staggering. We have to reconsider what we're doing. Being accused of something, and I can tell you because I do this for a living, half the people charged with crimes are found not guilty. Many of the charges are withdrawn as not substantiated. Many of the charges, including in my case, 14 murder cases, have been thrown out at the preliminary hearing stage because no reasonable jury acting properly could convict on this evidence. Yet, of course, being accused of murder is, of course, unbelievably devastating to an individual and usually results in them losing their freedom. So a mere accusation is really easy to make. And we really need to think very long and hard about the consequences that we impose on somebody before we do that. Yeah,
and John, I can tell you, I think it was the first 3 episodes touched in one way or another on the Me Too movement. And I've said this many times that I think it's great that people now take sexual harassment in the workplace seriously, but we've gone from one extreme to the other. Before it was buried, now the person is buried. There's no due process whatsoever. Their career is done. And we're seeing some examples of where things are handled properly. I mean, CTV and Steve Paikin, for example, they did a very fair investigation, ultimately found that the allegations were unwarranted, and he still got his job. And I can tell you, John, you see this from the criminal side, I see it from the employment side. There's a reason why investigations are critical. And I tell all of our employer clients this. If you suspect someone of misconduct, I don't care whether it's sexual harassment, theft, or tardiness, you need to be sure before you impose any discipline. And even then, it doesn't mean you can fire them even if they're guilty. But it's critical. So bringing this back to this context, so I get the call. I have an employer who will say, our employee has now been charged with simple possession. We want him out of here. And I will say, hold off. First of all, we don't even know if he's guilty. Even if he is guilty, that may not be cause to fire him. And then they say, okay, well, how long do we have to wait? And I'm not a criminal lawyer, but I know that nothing happens overnight, even though there are charter guarantees. But typically, how long is it going to take for that type of thing to be resolved?
The current rules, which are, of course, honored in the breach now more than anything else, are that a simple matter, a summary conviction matter, has to be determined in the courts by 18 months. The Supreme Court of Canada recently put out an edict effectively that said, we're going to put a hard cap on things. Before it was too much touch feel, if you will, about, the particular case. And they've made some exceptions for extremely complicated matters as well. But on simple matters, 18 months is really the limit. And realistically speaking, in major cities anyway, you're looking at probably about a year before something would be resolved completely. If you're in custody, it's quicker. Those are usually more serious matters. But if you're out of custody, just in terms of getting through the process, getting your disclosure, having your meetings, setting a trial date, arranging for that to happen, you're looking at about a year.
And that's critical for employers who are watching this to understand that nothing is going to be resolved overnight. And again, a charge is not a conviction. So you need to keep that in mind before you make any decisions. So thank you, Rob, for reminding me we have a question. I have to lean forward to actually be able to read this. I'm a U.S. patient and have had 6 months of cancer requests end with, "We are sorry, this is a drug-free place. What can be done?" So I'm not entirely clear actually on whether that's taking place in the U.S. or Canada. But in any event, I guess not so much, and I'm not sure on where the comment from is. I'm sorry, we're a drug-free place, so no more treatment.
It looks like a marijuana use. Yeah, a medical.
Oh, I see. Thanks for clarifying that, Rob. Sorry, John, do you want to go ahead and I'll jump in after?
No, it looked like it was someone using medical marijuana in the United States. And of course, marijuana in the United States, and perhaps your viewers aren't aware, is still scheduled as a Schedule I drug federally in the United States with heroin and cocaine. It's considered to be, has no medical value whatsoever and to be very dangerous. It's considered for the federal purposes, they have not changed it, to be a Schedule I drug like heroin. And so when you go across the border to the United States, there's this 1-inch barrier. You can go from a legalized jurisdiction in Vancouver to a legalized jurisdiction in Washington State. But at that border, you're dealing with heroin effectively. So if you're trying to go across that border and you admit that you've ever smoked marijuana, you're admitting to using heroin. If you say that you've ever passed a joint, you're admitting to sharing heroin. If you say that you've invested in a marijuana-based company, you've invested in the heroin business. That's how they treat it, and you will be banned from the United States for life. So she's the person, he or she that's putting the question, is trying to use marijuana for a medical purpose in a state in the United States that has not legalized medical use of marijuana. Many have, 26 have, and there's full legalization in 14 American states. So you're in a position where she's in the wrong state, and I guess she's either going to have to change things politically or she's going to have to seek a job in another jurisdiction. But if she is making an application that the feds have anything to do with, and they see that she's a medical user of marijuana, she's a heroin user, and she will be barred from the United States for life unless they bring an application, and even that would be difficult, for a waiver to get into the United States as an exception.
Yeah, a lousy situation to be in. And obviously I can't offer advice on the employment laws in the States, but feel free to email me and we can discuss offline, because I have a lot of colleagues in the US who deal with employment laws and may be able to help. But I want to bring the question back to the Canadian context where it certainly falls more within my expertise. And this is one of the things we talk about all the time with our employer clients is we have someone who now has a prescription for medical or medicinal cannabis. What do we have to do? Can we fire them? Do we have to accommodate them? And it's a no-brainer, really, from the employment law perspective. It all falls under human rights. You have a duty to accommodate, whether we're talking about addiction on one hand or medication on the other. Medication falls under the rubric of disability. You have to accommodate a disability. The same way that if you had an employee who's in a wheelchair, you would have to accommodate them to the point of undue hardship by providing either an elevator or a ramp or finding a way for them to do their job. Same thing in this context. If someone is using medicinal cannabis and they need time off, or they need to have their shifts rearranged or their work modified temporarily, whatever can be done within reason. The whole goal of our human rights legislation, it's important to keep this in mind. The goal of human rights legislation is to allow people who can work to do so and to avoid other unnecessary impediments, such as the fact that they're in a wheelchair or using cannabis. And the obligation is on the employer to accommodate them to the point of undue hardship. So if you're a small company, I'm going to use my wheelchair example again. You're a small company, you have one employee in a wheelchair, you may not be required to install an elevator because the cost might be too great. But if you have an employee who's using medicinal cannabis, first of all, not even clear if that causes impairment, because in many cases it won't cause any impairment. So the first question is whether there will be any actual impact on their ability to do their job. If there will be, and I've seen a few cases now where doctors have provided notes that will say, for example, that the patient will have to use cannabis 5 times a week. It can be done in the evenings, and they might be impaired for up to 3 hours. If that's the case, you now know what you need to avoid, so they're not working while they're impaired, and you will have to accommodate them to the point of undue hardship. And that, in this context, undue hardship is going to be pretty hard to prove. So we've got another question on Facebook. So let's jump in from Shannon. Thank you for sending it in. What recommendations are you making when it comes to burden of proof and its impact on company policies and application? So John, why don't I let you touch upon that first, and then I'll jump in on the employment side.
Well, we have a long-standing 100 years of theory that effectively say that you are presumed to be innocent of any accusation unless and until you are proved guilty to a standard of proof on, admissible evidence before an independent trier of fact. So just being accused of something should not in any circumstance cause you difficulty in your workplace. Now, obviously, if there's an independent investigation conducted by the employer, and the resistance to the new legislation was from hospitals and daycares and this sort of thing, where if somebody had been charged with a child sex offense and been acquitted of it, or been had the charges withdrawn years ago, the daycares and the hospitals still wanted to know about that, regardless of the fact that the person was presumed innocent. But they should conduct an independent investigation, and they should have what were the facts, what were the allegations, what was the evidence, before they just come to the conclusion that someone's guilty. So you really need to have an independent arbiter of evidence. Interestingly, and this is actually quite interesting, you can be charged with murder and you can travel to the United States because the Americans, despite all of their other problems, respect the presumption of innocence at the border. They do say, if you haven't been convicted of anything, we are not going to treat that as a negative consequence. Now, if it's a drug offense, they may ask in other aspects, do you use drugs? Have you used drugs? Because that will prohibit you. But if you're charged with a serious offense, you can still travel. And I tell my clients this because I get asked, they're on bail for a serious offense. I have to go on a business meeting. I have to go to the United States to visit family. Can I go? The answer for the most part is yes, because the Americans actually do respect the presumption of innocence at the border. So, it's a case-by-case basis. But to come back to what you were saying about accommodating for disability, et cetera, this is not going to be a shock, but there's an awful lot of people who are working that have medical issues. They might be on diazepam, they might be on, antidepressant medication, they may be taking any number of things, which are, of course, powerful drugs, but they're working. It's really about performance, and it's about impairment. Obviously, if you're driving an airplane and you have a medical marijuana license, you're still going to have to demonstrate, and there's going to be an investigation about whether you're going to be impaired driving the airplane. That makes perfect sense. Safety to the public is, of course, very important. The other thing, of course, is whether or not you're going to be able to perform your job. If you're being impaired to the extent that you're obviously not able to do your job, then that's something different. But there's a vast number of people taking all manner of medications already that are doing all sorts of things to them mentally and physically, and they're being accommodated. This is not the sky is falling. People who take medical marijuana are not walking around looking for Doritos. They are taking it to suppress pain. And interestingly, in jurisdictions of legalized marijuana, the opioid crisis has been reduced dramatically because people have a legal alternative to assuage their pain and their circumstances, and they are actually less users of opioids. So, there's lots of upside as well. But in the employment context, if there's an accusation made and there's no independent investigation, it's not appropriate for an employer just to say, well, there's smoke, there's fire, and you're out of here. That's not going to work, right?
No, and then by the way, you made some great points, including the Doritos one, which I always do in my presentations. And we got a question from @Mega Health, which I will definitely come back to because it's a critical point about what should be in policies. But I mean, John, you nailed hit the nail on the head. I mean, I've written a book. It's called You're Fired. Nothing to do with Donald Trump, but it's all about just cause for dismissal, when you can be fired for misconduct. The book, which is behind me, you may be able to see it. It's about this thick. Because the law is so complex. But one of the critical points is the one you just made. Allegations or suspicions do not equal guilt. So the employer must engage in an independent, objective investigation before making any conclusion. And even if you find the person's guilty, you may not have cause to fire them. But to bring it back to the question, one of the challenges that people foresee here, although I don't think it's as difficult as people make it out to be, is if you suspect someone is impaired, if you suspect they're high, how do you prove it? There's no equivalent to a breathalyzer. One of the points I often make, though, is most employers don't have breathalyzers in the office. And there are lots of cases, and I've seen this, I've handled them, where people are suspected of being drunk at work. And they're suspected of being drunk because of other factors. They may be walking off balance, they may be slurring their words, etc. And at the end of the day, unlike in your world, John, the burden of proof in the civil context is not beyond a reasonable doubt. It's a balance of probabilities. In other words, what is more likely than not? So as long as there are enough indicia to show that it's more likely than not that the person was, in this context, impaired, then you can find that they engage in misconduct and consider discipline. It's not a beyond a reasonable doubt standard. And one of the things I was going to turn this back to you, John, is I know that there are a lot of concerns that how are the police going to handle this? Now, how do you figure out if a driver is impaired when there's no equivalent to a breathalyzer? So I'd be curious to know what you understand about that.
Well, the difficulty, of course, is that if you do a blood test and you get so many nanograms of cannabis tetrahydrocarbonol in your blood, it doesn't mean you're impaired, because that stuff stays in your blood for weeks, indeed for quite some period of time. As Ross Rebliati found out, remember our snowboarder at the Olympics.
A blast from the past.
Well, he was one of the first people that was, because they do have such stringent testing at the Olympics for blood tests, right? But the problem is that it doesn't mean you're impaired. The levels of cannabis in your blood do not necessarily mean that you're impaired. So they have what are called drug recognition experts. And of course, it's fascinating to us in criminal law that the police somehow managed to suggest that it's going to cost them millions of dollars more for a legalized substance than it was for an illegal substance. They're advocating for a massive influx of money. I guess they're going to miss marijuana when it's gone. And of course, the federal government has managed to put in 18 new criminal code crimes as a result of the new legislation. But they don't have a way to really test properly. So it's really a question of opinion. You have a drug recognition expert that can do physical tests, look at your pupils, look at your eyes, listen to your speech and your recognition of various tests. And they will go and make an opinion in court that says, we believe this person was impaired by drugs. And the blood test really only confirms that there's any drugs in the system. But the actual level of drugs isn't going to be established. Now, the same is very true, and I've made this point to you before, Stuart. Really, in the workplace, it's not that difficult. It's alcohol as well. You're in a position where somebody comes back after lunch and they're slurring their speech and they're not walking properly and their eyes are red and bloodshot and they're not acting in a coherent way. It's not all that hard for people to figure out you've had too much to drink. Well, it won't be that hard to figure out if somebody is, asleep at their desk or nodding off or having trouble, following conversations. So realistically, I think it's going to be an opinion-based thing, and, there'll be an investigation done, and I'm sure questions will be asked as well. But blood tests aren't going to do it. And as you say, there's no breathalyzers in the workplace. People aren't going to be taking blood in the workplace either. So it'll be difficult indeed to establish, on a scientific basis what the situation is. It's going to be opinion-based.
Yeah, and I always tell our clients this, whether it's you doing the investigation or a third party, as long as the conclusion is defensible, that is what you need to be comfortable with. And there was a great case a couple of years ago where an employee was fired for breaking the no smoking rules. And what was the evidence? No one saw her with a cigarette in her hand. What they saw was smoke coming out of a stall in the bathrooms. They saw her come out, and her clothes reeked of cigarettes. So the conclusion was that she was the one smoking in the bathroom. And you know what? A judge, she actually filed a wrongful dismissal claim in that one and went all the way to trial. And she lost because the judge said it was perfectly reasonable to conclude that she had been the one smoking. So
it's the one case where there is smoke, there's fire, I guess. That one.
That was you led with that, and I was going to bring it back to it. But that was one of the few examples where it's true. So Rob, I know we had another question waiting, so let's come back to that. I think it had to do with policies. So this is on Twitter from @MegaHealth. So what are the absolute musts when it comes to workplace policies related to impairment at work? So thank you, first of all, for the question. Thank you. This is actually one of the things I'm going to talk about when I get to do my fire away segment at the end of this episode. But here's one, there's a whole bunch of things you need to do. And the very first thing you need to do is recognize that the standard drug and alcohol policy that I see essentially says, thou shalt not consume or be impaired by drugs and alcohol at work. That's not going to do it. That's a good starting point. But you need to realize a number of things. First of all, you may well have employees who are consuming alcohol in the course of their duties. For example, their salespeople who are wining and dining people. They're expected to go out and have drinks with their clients. And technically, if your policy says thou shalt not drink, they're breaching the policy. Second of all, and John, you alluded to this earlier, employers are all up in arms now because you may have employees using cannabis medicinally, and it might cause impairment, although it may not. They never gave a second thought to the fact that they probably have employees right now using other prescription drugs that can cause impairment, such as Oxycontin, and yet that's never been an issue. So you need to have a policy which addresses, first of all, what is prohibited, being impaired or usage at work, the exceptions such as alcohol at dinners and things like that, exceptions for things like medicinal usage, and perhaps you create a policy where people using medication that might cause impairment have a duty to report that. And then you can assess whether it's an issue or not. If it is an issue, you're going to need to accommodate. So you need to make sure your policy is very clear on the need to accommodate. When it comes to addictions, that's the other thing you're going to have to deal with. Human rights protects addiction, which is seen as a disability. And there was a great case at the end of 2017 where an individual, in that case, he was addicted to cocaine. And the company had a very thorough policy, which essentially said, if you have an addiction, you are to report it. And if you report that, we will work with you to help you. But if you don't report an addiction, if there's then some sort of a workplace incident and you're found to have been impaired, then you will be fired. And that's exactly what happened in that case. The individual had an addiction but didn't disclose it. There was a workplace incident that was egregious enough to warrant testing. He was found to have been impaired. He was fired. He grieved it. That went all the way up to the Supreme Court of Canada. And in that case, the dismissal was upheld. And the court found that he was not fired because he had an addiction, which of course would be a breach of human rights. He was fired because of a breach of policy. So you need to make sure your policy is very clear on all these points, including the consequences of a breach. In other words, will there be discipline? Will it be dismissal? Will it be a multi-step process? Whatever the case may be. And then I'm going to talk about this again at the end of the show, but you also need a very clear procedure. So what happens when someone comes to you and says that they have been prescribed cannabis or any other drug that could cause impairment? What happens to you when someone is found or suspected of being impaired? And this gets back to the point you were talking about earlier, John, which is if someone is suspected of being impaired, it's no different than if they are suspected of having stolen property from the company or have been late or engaged in insubordination. There's going to be an investigation. So that's two of the things that we're working with all of our clients on weekly at this point, if not daily, to make sure that they are ready, because otherwise, as you said, the world isn't going to end on October 17th, but now is the time to update your policies.
The other absolute must, of course, is public safety. If you're a police officer with firearms, if you're driving a bus or an airplane, obviously then your level of intoxication impairment has to be pretty much zero. You have to be in a situation where if you are taking prescription medication of any kind, it has to be disclosed. There has to be an analysis about whether or not there's any level of impairment. You know, if you've got 500 people in the back of an airplane that you're responsible for, you had better be on your best game. So public safety is the other issue, of course, and that's a very reasonable restriction. In fact, there are some institutions, perhaps the National Hockey League is one of them, where you're in a situation even then where you have to have a zero tolerance policy for all sorts of things because of the level of public safety that's involved as well. And so in those circumstances, it would be a disclosure problem. And of course, as you say, there are other consequences, that there has to be reasonable accommodation, you know, maybe a desk job if there's a particular issue for 6 months where they're getting treatment for cancer or whatever the case may be. But you're in a situation where public safety is the other absolute must, isn't it, Stuart?
Oh, absolutely. And that's what's interesting in this context, because we always talk about the duty to accommodate, and we always say it has a limit. It's the point of undue hardship. Right. What does that mean? It's one of those nice legal terms that, you know, judges say they'll know when they see it. But usually we're looking at cost. You know, you go back to my wheelchair analogy. You know, a company might say, well, we'd love to accommodate this person. We can't afford to put an elevator in or a ramp in. And that's often the biggest factor. In this context, it's safety, absolutely. And so you're never going to be told that you have to allow your truck driver to get on the road while they're impaired. But you're going to have to look at safety of the individual, safety of their colleagues, safety of the public. All of these things are going to be the key consideration. And as you said earlier, I mean, if the evidence from the person's doctor is that they may be impaired for up to 3 hours, and it's going to be, you know, once a day for 6 months, well, when do they have to ingest it? Maybe it's off hours, so it's completely irrelevant. Or maybe it's every day at noon and their shift is 9 to 5. So let's see, if you're a big enough organization, you might be able to accommodate them by adjusting their shift so they work from, you know, 4 to 12, or they get a certain period of leave of absence. Whatever the case may be, that's the analysis you have to go through. And one key point there, because a lot of individuals don't understand this. If you ask for accommodation, and I don't care whether we're talking about childcare accommodation, disability, medicinal marijuana, addiction, etc., you have to be part of the process. You as the employee have to produce the documentation. There are privacy limits here, so you're not going to disclose your diagnosis or your full medical record, as I've seen some employers ask for. But you need to give the employer enough information to understand what the impact is going to be on their ability to do, on your ability to do your job. Then they can assess whether accommodation is possible or not. That gets all thrown into the mix in this context.
Isn't it amazing that in this context, fair play and general kindness seems to be the rule? You have to be kind to people. If people have a problem, you have to be kind to them. You have to understand what they're going through, why they're going through it, and you have to accommodate and try to assist them. And that's the entire point that we're hoping that gets more widely disseminated in our society about drug addiction and drug problems. You have to be kind to people. Putting people in jail because they have a disease is neither kind, fair, nor sensible. If people are using oxycodone because some doctor prescribed it for a back, they got addicted to it and then went to the street when the prescriptions ran out, they have a problem. It's a medical health problem. And to suggest that you're going to get people to stop taking drugs and to cure a problem like that by putting them in jail is like saying, don't have cancer. We prohibit you from having cancer. We're going to put you in jail if you have cancer. Don't do that because you're a bad person if you have cancer. This is insanity that does not work. You need to be kind to people. You need to try and help people as best you can. And you need to be open-minded and fair-minded about what the problems are. And if you do that, we're going to be a lot further ahead.
I love the way you started that comment by saying, isn't it crazy that we're looking at things like kindness? It shouldn't be crazy to think of it that way. This is what I say to clients all the time. And I know clients, and whether they're employees or employers, they always question me when I say this. But a lot of this does come down to common sense. And it also does come down to fairness and kindness. And in this context, yeah, you shouldn't put somebody in jail because they have an addiction. You shouldn't fire someone because they have an addiction. That's why we have human rights legislation across Canada that essentially prohibits that. And it doesn't mean, to answer what I anticipate will be the objection, again, it doesn't mean you have to let someone come in and get high at work. It doesn't mean you have to let them get behind the wheel of a truck when they're impaired. But you are going to have to find ways to accommodate them. You can't just fire them because of an addiction the same way you can't fire them, to your analogy, because they have cancer.
Well, we're in a world now where Bell and other companies in the corporate world are respecting the issue of mental health problems. They're treating mental health as a medical health problem. We need, as a society, to treat the usage and misusage of drug as a medical health problem. Because when we do that, we're going to be a lot further ahead. We're going to solve the problem. If you look at the countries that have decriminalized drugs, and the Toronto Board of Health yesterday called for the complete decriminalization of all personal use drugs, heroin, OxyContin, anything, the complete decriminalization, because the criminal justice system is a large mallet. And unfortunately, drug addiction requires fine tuning with little screwdrivers. It is not going to work hammering people for drug addiction. You're not going to fix the problem, and you're not going to move our society ahead. So if the employment context can move to lead this issue with the human rights codes and the employment codes by saying to people, you have to be kind to your employees, you have to help them when they're ill, you have to attempt to make them better, you have to accommodate them, then we're going to hopefully get that sort of an attitude to be much more widespread.
Yeah, I think we will. I certainly hope we will. And again, it's always in the context of you are running a business, and there is, aside from the not-for-profits, there is a profit to be made. But nevertheless, there is an ability to be, as you put it, kind and fair while still doing that. And especially in the not-for-profit sector. And our firm works with a number of not-for-profits. And it's often surprising to me how even the not-for-profit sector, sometimes they become so focused on doing business, quote unquote, that they forget about being kind and fair to the employees. So this is hopefully going to be a bit of a reminder. So I'm almost out of time. And Rob, I think you're scribbling. Hopefully that means we have one more question. Oh, just a reminder of the time. We're on the same page exactly. So thank you. So I don't think we have any more questions, but and John, I know you can go on and on for hours, which is why I'm
sorry about that.
No, don't apologize. That's why we booked an hour, because you've got a lot of really great things to say, and I found it fascinating. I'll give you the chance for a last word.
Well, all I was going to say about the employment of marijuana legalization is let's be adults about this. Let's not freak out that people smoke joints. Guess what? People smoke joints. People take a drink. Most people do that responsibly. They do that on Saturday night with their friends. And it's not going to be this critical issue in the employment context that people may be imagining. And I think the reefer madness needs to end. And then hopefully after October 17th, when the sky doesn't in fact collapse, people will get to treat this as an adult problem.
Thank you, John. And again, thank you so much for taking the time away, not perhaps from your cottage, but at least from the dock. We certainly appreciate that. And it might be a lot of fun to reconvene perhaps next summer. We'll have 3/4 of a year under our belts and see how things have played out. And as we discussed before we went on air, maybe we can do that on the dock next time.
You'd be very welcome.
Thank you again. And for anybody interested in learning more about John and his practice, you can check out www.johnstruthers.com. But John, thank you once again. I really appreciate it. And now I get my turn to fire away. So on episode 6 of Fire Away, we talked about the upcoming decriminalization of cannabis, as well as the fact that the medicinal cannabis is lawful at this point. We had John Struthers join us and had an amazing conversation. I'm glad we booked an hour for it, on many of the impacts that we're going to see in our society, including in the workplace. Not surprisingly, my comments are focused on the workplace. And one of the things I find fascinating, and the image that you see behind me of Snoop Dogg is one that I've been using in presentations. I've been talking about, medical marijuana, cannabis, weed in the workplace for about 2.5 years now. And I've gone to the Maritimes a number of times across the country, talking about employer groups, to benefits groups, et cetera, about what to expect. We start off talking about medicinal cannabis. And of course, then our current government announced that we're going to legalize recreational cannabis. So the discussion has changed. But one of the points I want to make is a point that John Struthers made in episode 6, which is the world is not going to end. We now know it's October 17th. When marijuana will be decriminalized. The world is not going to end. The sky is not falling. I speak with a lot of employers, and the initial concern was essentially that their lunchrooms were going to become a drug den, or that their truck driver was going to, they were going to have to allow the drivers to get behind the wheel when they're impaired. None of that is ever going to happen as far as a drug den goes, as long as you don't let it happen. But the laws are not going to require that you go that far. So there's no need to panic. But you also can't bury your heads in the sand. And this is something that at Rudner Law, we're working with our corporate clients and also our employee clients to understand what the law means and what it doesn't mean. One of the things that employers need to understand is you need to reflect or understand the current reality. Many of your current employees are using prescription medication that can cause impairment. It might be Oxycontin, it might be something else. And the reality is you've never really thought about that. But all of a sudden you hear the word marijuana and all of a sudden it's a disaster and you need to deal with it. Or you have a policy in place, and I see these all the time, which says thou shalt not consume or be impaired by drugs or alcohol at work. And that's kind of the standard drug and alcohol policy. And of course, no one has ever turned their mind to the fact that they have salespeople out there who are wining and dining clients and probably having a drink or two or three while undergoing or carrying out their duties. Technically, it's a breach of the policy. So when you're going to adjust your policies now, which I think everyone needs to take a look at them, you need to make sure that they are consistent with the reality and also with the new laws. So what do you need to do? First of all, as an employer, first thing, have a look at your policy. Hopefully you have one, but it probably isn't consistent with the current reality. So you can have a starting point of you will not use or be impaired by drugs or alcohol at work. Then you got to put in place all the exceptions. Maybe you have salespeople who are drinking. Maybe you have staff parties. Maybe every Friday you have beer in the boardroom. Whatever the case may be, make sure that you're not actually encouraging people to breach the policy. Second of all, put the exceptions in place for things like prescription medication. So one thing I've seen done very successfully is have a policy in place which says if you as an employee are prescribed medication that could cause impairment, you have a duty to disclose that. And what happens at that point? You don't fire the person. You take into account what the impairment might be, assess whether it's going to impact their ability to do their job at all. It may not. If it does, then you can assess whether you can accommodate them, and if so, to what extent. One important piece of advice that we have to tell our employee clients all the time is when you make that request for accommodation, or if you come in and say that I am addicted, for example, to drugs or alcohol, that's not the end of the discussion. Any form of accommodation has to be a two-way dialogue. So you've got to produce enough information for your employer to assess whether there will be any impact on your ability to do your job or not. If there will be, they can then assess whether they can accommodate you and how so. And one important point to make, you as the employee don't get to choose your preferred form of accommodation. As long as the accommodation is reasonable, then the employer can impose that and they're not breaching their duty. What they can't do is say, we're not going to accommodate, and that's the end of the discussion. So that's, I guess, my next tip for employers. Never, ever dismiss any request for accommodation out of hand. And that doesn't matter whether we're talking about medicinal marijuana, we're talking about addiction, we're talking about childcare, we're talking about somebody in a wheelchair. The process should be the same. Have a very clear procedure for how every request for accommodation is handled. You won't go wrong. Most of the cases where we see employers getting in trouble is because they didn't realize that they really had to take this request seriously. That's the example of the case several years ago now, where the right to accommodation for child care obligations was confirmed by our Federal Court of Appeal. And in that case, the employer essentially said, we had a process in place for dealing with requests for accommodation. But as far as they were concerned, that related to disability and not to things like childcare. They didn't follow it. So put a process in place, make sure everyone knows about it. And that's really the third point, training. So we're talking about cannabis, medicinal or recreational. First of all, get educated. As an employer, one of the things that I'm seeing as I do my presentations, as we work with our clients, there is so much misinformation. There is so much fear. Again, the image of Snoop Dogg in your lunchroom or the guy behind the wheel when he's impaired and you having no ability to stop him. It's all misinformation. So understand what the reality is socially, medically, and legally. And then make sure everyone is trained so that your managers, your supervisors, and your employees all understand what the law says, but also what your policies say. And in particular for the employees, make sure they know that if they have a duty to disclose something such as impairment or a prescription, make sure they know that they have that duty. And then make sure that your supervisors and your managers know what they're supposed to do when that happens. Make sure everyone is clear on the policy and the process. Otherwise, that's where we see our employers getting into trouble, is the fact that they have a policy, it might be the best policy in the world, but nobody knows what it says. Last thing to remember is you've got to ensure that everyone is treated, and I'm going to harken back to episode 6 and John Struthers' comments here, fairly and with kindness. That doesn't mean that you're not running a business, and you don't have to accommodate to any degree. One of the questions that I'm often asked in this context is, can't we just have a policy which says you will not consume drugs or alcohol or be impaired at work? If someone breaches it, we'll fire them. And my answer is no, you can't. That's a great starting point, but our human rights legislation has a purpose, and it's often helpful to take a step back in the context of this discussion. Remember, the purpose is to allow people who can work to do so. So the same way that you might have a very valuable employee who suffers a car accident and is now confined to a wheelchair for 3 months or 6 months or for the rest of their life, you're not going to fire them because of that. You're going to have to accommodate them. Accommodation might mean an elevator, a ramp, setting up offices on the first floor instead of the third floor, whatever the case may be, you're going to have to accommodate them. The same thing applies to someone who is addicted to cannabis or prescribed cannabis for a bad back or for cancer treatment or whatever. Remember as well, though, that the duty to accommodate is limited. It's to the point of undue hardship. That's one of those legal contexts that we know. Judges will often say we know it when we see it. But the point is, in the context of cannabis, safety is often the issue. You're not going to be expected to jeopardize the safety of the individual, of their colleagues, or of the public in the name of accommodation. So you're not going to be expected to put the person behind the wheel of a truck when they're impaired. But you will be expected to adjust their shifts, adjust their duties, give them a leave of absence, find a way to allow them to continue to be employed and allow them to work through whatever issues they're dealing with. So those are really the points that I wanted to make. We had a much more fulsome discussion in episode 6 with John Struthers on a whole lot of the issues. But I will close, as I usually do, by reminding everyone that, first of all, these episodes are online monthly. Past episodes are always available online on our Facebook page, on our YouTube channel, and on our website. If you have any questions or suggestions for future topics, you can email us, you can post on Twitter, you can also post comments on Facebook. We'd be glad to receive those. But the other point I always like to make, and you've heard me say it before, at Rudner Law, we really believe in education. And it's education not only for our clients, but for the general public. That's why we put on the shows like this. That's why we have our Twitter feed, our LinkedIn feed, our Facebook feed. We have a newsletter, which I encourage you to sign up for. So please take advantage of the information that we offer out there, as well as I've mentioned throughout episode 6 and in this section today, this segment today. We work with clients, employers, employees. We design policies, procedures. We help them deal with requests for accommodation. We work with individuals who have been fired or suspended because of the fact that they are addicted or are using medicinal cannabis. So feel free to reach out. And I often say this, the information we provide is not a replacement for legal advice. If you suspect that you need an employment lawyer, you probably do. So reach out. We'd be happy to talk to you and determine if we can help you. And if not, there's no harm done. But feel free to check out what we offer on our website and our social media pages, and then reach out to us and see how we can help you. That's it for today. So thank you very much for tuning in. And thanks again to John Struthers for joining us for a really interesting discussion. And I look forward to next month. And I'll remind everyone, next month is August 21st. We're going to be discussing civility in the workplace with Sharon Bar-David.